Good afternoon, everyone. Thanks for joining us for this month's session on tax education webinar. I have with me today Kristen Tigrum from the Iowa State University. She's going to speak to us today about bankruptcy in the farm. My name is Janet Wright. I'm with FSA Office of Outreach. And before I turn it over to Kristen, I want to remind you that this presentation is being recorded. You will receive an email from me in about 2 weeks letting you know that it has been posted to farmers.gov/taxes. Before then, you can feel free to go over there and check out some of the previous webinars that we've done over a myriad of topics. There's a lot of information there that will be beneficial to you. Christine is going to answer questions at the end of this session, so please put your questions into the Q&A chat, and she will try to answer as many as possible before the end of our time together. So with that, I will turn it over to Christine.
Thank you so much, Janet. I am really glad to be here today to talk about what I think is a timely topic, an important topic. I also just want to start with a little bit of perspective. When we talk about farm financial distress or farm financial difficulty, we hear a lot of stories of different farmers having different issues going on at this time. But in terms of Chapter 12 bankruptcy, which is the family farmer bankruptcy chapter, which this webinar is really going to focus on, we can see the numbers. They've been creeping up, but we're nowhere close to the numbers that we had, say, back in 2012. So just wanted to kind of start off this session with a graph that kind of showed where we are right now in terms of the number of farm bankruptcies that have been initiated during the past couple of years and in the past. Now, I did want to say this is for Chapter 12 only. And Chapter 12 is the special family farmer bankruptcy chapter. And we don't really have a good way right now. There are many of us trying to figure out how to determine how we could see the number of farmers that are filing bankruptcy under the other chapters that I will briefly discuss as well, Chapter 7 or Chapter 11. So when you see numbers like this, these numbers are strictly family farmer bankruptcies filed under Chapter 12, which are reorganization bankruptcies. And the whole purpose of today's webinar is to kind of update you and to educate you on what that exactly is. Because just in general, the purpose of bankruptcy is something that goes way back to the founding of our country, really, where the idea was that we don't want debtors to be so burdened by debt that they never have an opportunity to sort of start again. And so a quote from the Supreme Court back in 1934 says, "Bankruptcy gives to the honest but unfortunate debtor a new opportunity in life and a clear field for future effort, unhampered by the pressure and discouragement of pre existing debt." That's a good synopsis of why we have bankruptcy laws, what they're for. They are in place to help debtors who are in a place where they can't just restructure, they can't just come up with a workaround to be able to put debt behind them and move forward. But the thing I want to tell everyone on this call is that bankruptcy is not the best option usually for financially distressed farmers. It is not the only option. Sometimes it is, but it's not necessary for everyone. If it is possible to renegotiate loan terms with your lenders, that is the best option. In many cases, lenders will work with you because it's very costly for them to have you go through bankruptcy. It's not something that they are longing for you to do. So my suggestion is to get help as soon as possible when you're facing any sort of farm financial distress. You really need to seek counsel that is experienced in farm financial impairment issues. And you need to do it sooner rather than later because there are some options that you might have now and that if you don't pursue them in a timely manner, perhaps before certain liens are filed, etc., they might not exist later. And again, anything dealing with bankruptcy, with farm financial workouts, anything that involves complex matters of trying to get out of debt that is currently not sustainable is not a do it yourself project. You have to have legal counsel in order to file a bankruptcy petition. And I am suggesting that you should seek legal counsel, even if what you're seeking is a workout or a financial plan that allows you to restructure your debt in a way that's sustainable. So those are the pre, I guess, words that I want to say before we just dive into bankruptcy, because bankruptcy is the topic of today's webinar. But I don't want everyone to just think, oh, bankruptcy is the only option if I'm facing financial distress. Now, within bankruptcy, which is, of course, federal law, there are several chapters, and you can see them listed here on my screen. The ones in bold are the ones that would be possible options for farmers. Chapter 7 is liquidation. That means you're getting out of business. Chapter 11 is business reorganization. You are going to stay in business, but you need to reorganize because the current way that you're doing business is not financially sustainable. You are not able to pay all of your debt right now. And so, Chapter 11 exists for the largest companies in the US, as well as smaller companies as well. Chapter 11 is an option for some large farms. Chapter 12 is the Family Farmer Reorganization chapter. This one was created in the 80s specifically for farmers. And we're going to spend most of our time today talking about what are the requirements, what would be the benefits, what would be the drawbacks. And then Chapter 13, it is also a reorganization type of a plan, but it's really for consumers. It is really driven by consumer debt needs, but it is a payment plan where you're not just liquidating, paying everybody off at once. There's a plan over a number of years. I will not be discussing Chapter 13 today because even though in very rare cases it might be an available option for a family farmer, it mostly is available for consumers who have a lot of consumer debt and also have income, so they're able to pay some of that debt. And so, really, the primary chapters that a farmer would use if they are seeking some sort of relief from the bankruptcy court because of debt are chapters 7, 11, and 12. And so I'm going to give you an overview of 7 and 11, but ultimately I'm going to focus on 12 because it is the special reorg chapter that if you can qualify, it's probably in most cases going to be the best option for family farmers and fishermen. I will also say that because this webinar is only an hour, I'm only going to focus on the farmer provision, not the fisherman provisions within chapter 12. Now, there are some things about bankruptcy that are common across all of the chapters. And the first one is bankruptcy is voluntary. This is something that a farmer would determine that they would want to file. And it is started when you file a petition with the bankruptcy court. And again, this is not a do it yourself project. This would happen after you have consulted with an experienced bankruptcy attorney. You've given them all of your data. There've been all of the worksheets and the schedules, and all of the income information has been collected and analyzed, and it's been determined that bankruptcy really is the best option for you. Now, just a general requirement across the board for federal bankruptcy is that credit counseling has to be completed before the filing of a petition. But again, experienced bankruptcy attorneys know what they're doing. They're going to be able to work with you to do what you need to do. Now, it's interesting, as soon as you file the petition, it is called an order of relief. Now, we're just usually getting started in the bankruptcy by filing the petition. So I just wanted to give you that language in case you see it and get confused, because that makes it sound like everything's over, but it's not. Now, what does happen at the time that a bankruptcy petition is filed is we have what's called an automatic stay. And this is sort of the time to breathe. As soon as a bankruptcy petition is filed, the automatic stay kicks in. And what that does is it temporarily, not for all time, but it temporarily prevents creditors from filing lawsuits, from seeking foreclosure, from filing any liens, from seeking garnishment, from doing anything to collect debt. It's kind of just a temporary pause that allows you to create your plan. Now, once the plan is created and once we get moving forward in bankruptcy, it definitely doesn't mean that secured creditors in particular won't have access to their collateral or won't be able to uh, get recovery for collateral that is been put in place to secure a debt. However, during the automatic stay period, no collection action can take place. Now, because of this, the bankruptcy court, they are going to be overseeing all debt matters. They're going to oversee tax claims, tax determinations. They are responsible for tax discharges. The bankruptcy court has a lot of responsibility. Now, the first chapter, again, it's all U.S. bankruptcy law, but it's divided into chapters based upon the type of bankruptcy and the needs of the debtor. And so the chapter 7 chapter is for liquidation. And liquidation is exactly as it sounds. It means you are liquidating your assets. It's kind of like the fire sale. You are selling everything, dividing up the proceeds amongst the creditors. You are getting out of business. So, if you're a farmer who is saddled with debt and you are ready to get out of farming and you have debt that exceeds your assets, you may need to seek bankruptcy protection. And this again applies only if you're no longer going to be filing, because the liquidation bankruptcy is going to create an estate with all of your property. And the goal of the proceedings is to take all non exempt assets and sell them and distribute them accordingly to the creditors. Now, of course, secured creditors, they'll have the ability to get their collateral back. It's all dependent upon what the different terms of the loans are and the different status of the creditors and the different positions that they have. Because in the credit world, not every creditor has the same standing. Some, if they're secured, if they have collateral, they're of course higher up the chain than the unsecured creditors who just issued credit but don't have any collateral backing it up. Then there are other claims like the administrative claims for the cost of the bankruptcy that would never be paid unless they had a priority ahead of some of the other claims. So with a liquidation, the trustee is put in charge of collecting all of the assets. They'll pay the cost of administration. They'll pay the priority claims like child support and tax debt. The secured creditors are going to retain their security interest in the collateral. And many times in a Chapter 7, the unsecured creditors will not receive anything. It just depends on if there are assets or money to go around. If there's some, but not enough to pay all of the unsecured creditors, then they will share the estate or the property on a pro rata basis. So a liquidation is just get out of business. And then the goal is once that property has been distributed, then the benefit of a bankruptcy is that the individual debtor is going to receive a discharge. That means it releases them from the personal liability of that debt from then forward. So if it's dischargeable, which most debt is, some debt is special and it's not. Child support, some student loans, some debts like that you cannot discharge through bankruptcy. But really, the policy in this country is other debts are dischargeable if you go through the proper bankruptcy proceedings. And so the discharge says once I am done with the bankruptcy, no creditor can come after me to collect the debt that was taken care of in that proceeding. Now, it doesn't mean that your credit rating will allow you to get credit in the future. It just means that you will not have creditors filing actions against you for any of the debt that was resolved in that Chapter 7 bankruptcy. Now, Chapter 7 does not liquidate all property the debtor owns. And that is because the law does recognize that every person needs some amount of property just to live. And so there's a classification of property called exempt property that you get to keep as a debtor if you file a bankruptcy. And so in Illinois and Iowa, for example, those states would use their own state exemptions, but Wisconsin uses federal exemptions. So states are allowed to replace federal exemptions with their own. Every state has a different rule. But just to give you an idea, since people on this call are from all over the country, what types of exemptions you might have, I just listed the current federal exemptions and some of them. And so you may keep an automobile with up to $5,000 in equity, a child support, alimony that you receive, because that's intended to provide for your daily living or your child's daily living. If you have any health aids, those can't be sold. Tools of the trade or books, up to 3175, jewelry, personal injury settlements. You can see pensions and IRAs, you can keep up to $1.7 million as exempt property. And then a homestead, you can keep up to 31,000 in equity. So those are exemptions that apply to bankruptcy proceedings, just so that debtors aren't left without a place to live or cars or things that they need to for their daily living. Now, with a Chapter 7, there is a law that was passed all the way back. It's been now 20 some years ago that prohibits consumer debtors from discharging debt under Chapter 7 if they have means to make payments. So, this was meant to address the situation where perhaps somebody ran up a whole bunch of credit card debt. They had significant income to pay, but they didn't have assets that were sufficient to pay for that debt. And so Congress said, anybody that has a certain amount of income should be required to at least pay some of their creditor debt. And so that means that they will look at income and require a payment plan under Chapter 13 if you make enough money and your primary debt is consumer debt. Now, with secured creditors, remember, these are the creditors that have collateral, and they're generally entitled to retrieve non exempt collateral unless the debtor chooses to redeem or reaffirm the debt. And so sometimes in a bankruptcy, the debtor is allowed to have some funds to be able to just buy out the collateral from the secured creditor, or they could reaffirm and show that they are able to pay the original terms of the note, and in that case they can keep the collateral. Debtors generally have 30 days from the filing of a petition to make that declaration. And remember, with secured creditors, they're only entitled to the value of the collateral up to the amount of the debt owed. They don't get to keep that excess. So really, when we're looking at Chapter 7, this is the chapter that's used if you just need to get out of business. It is usually fairly inexpensive. It's efficient. It generally just takes about 90 days from filing to discharge. If you're a farmer who's ready to get out of farming and is not planning on continuing to farm, Chapter 7 would be the option to look at. The disadvantage is that you're getting out of farming. Your farming assets will be gone. You don't get to leave a Chapter 7 with holding on to assets. You are just selling everything and dividing the proceeds up amongst your creditors. Now, chapter 11 is the second chapter that we're going to look at today, and this is a reorganization chapter. So, with chapter 7, it means, okay, my business is going to continue. And chapter 11 was designed for business debtors. So, this would be for all debtors that are in business across the country. So, if you think of the biggest corporations, if they have financial trouble, and they want to stay in business and try to reorganize their debt and continue to operate, Chapter 11 is the petition they would file. But the unfortunate part of Chapter 11 is it's usually complicated, it's usually expensive, but it has no debt limit. In a Chapter 11, creditors have fairly significant rights. There's a creditors committee. It ensures the fair representation of to the unsecured creditor. The debtor has 120 days once the bankruptcy's filed to file a reorg plan, and then another 60 days to have that plan accepted by the creditors, or 180 total to have the plan accepted by the creditor. And the creditors in a chapter 11, without going into too much nauseating detail, have the ability to reject a plan or say no to a plan. They do have some power. Now, again, everything I'm going to say today about bankruptcy, it's at a pretty high level. The bankruptcy law is very detailed, it's very complicated. So we're not going to dive into all of the details. I'm just trying to give you a fairly high level understanding of how this works. Now, there are requirements in a Chapter 11, first of all, that a plan be feasible. Now, what does that mean? It means that if I come up with a workout plan, a way to restructure my debt, a payment plan where my creditors are going to get paid, I have to be able to show that I will have significant income significant enough to actually make the payments on my plan. If it shows that this payment plan is not possible, the plan will not be feasible and the plan will not be approved. Now, all bankruptcy plans, whether it's chapter 11, chapter 12, they have to be made in good faith. Sometimes we will see a bankruptcy case dismissed because a court will find out that a debtor has not been honest about their debts, has maybe hidden collateral. None of those things will fly. And so, if it is discovered that there has been a lack of good faith, the bankruptcy petition will be discharged. The debtor will not be available to have the bankruptcy protection. And in Chapter 11, this plan has to be in the best interest of creditors. There has to be adequate protection provided to secured creditors. And that means that if the debtor is going to continue using the business property that is secured by a creditor, like it is the collateral for a loan made by a secured creditor, there has to be some sort of extra payment made or some kind of protection for that secured creditor, that while they are waiting for their payments under the plan, that collateral that they could technically have seized before you paid, before you filed the bankruptcy and sold and gotten the debt paid, will not lose value so that their position is impaired. The big thing in a chapter 11, which is often the very difficult thing for a farm, is that absolute priority rule has to be followed. That means that in a certain class of creditors, everybody has to be paid before anybody underneath can have anything. And debtors can't retain property unless the plan provides for the payment of all debt, unless the creditors agree otherwise. So, if the plan is not sufficient to make payment of all debt, then the debtor in Chapter 11 cannot retain any equity in their property. And that is a big problem for farmers who need to use their property in order to continue their business. So we'll get more into that when we look at chapter 12. Chapter 11 does have some helpful features. You can restructure to have longer payment schedules. And sometimes you can have up to 15 to 30 years to make payments for real estate loans, 3 to 7 years for machinery. Interest rates are generally 2% greater than the yield on the US Treasury notes. After filing the Chapter 11, though, the debtor has to seek approval of a court in order to get any additional secured debt. You can see the court has to approve different things. There are monthly reports. Trustees' fees are paid by the debtor. The Chapter 11 provides no specific time period for re making repayments under the confirmed plan. That's because that can all be determined under the plan that must be approved by the creditors. So, in a nutshell, I'd say Chapter 11 is really helpful for large debtors that want to restructure and reorganize. Chapter 11 is available and it is used for farmers who want to continue in the farming business, but they're not able to qualify for Chapter 12 relief. Sometimes it's because their debt is too high. Sometimes it's because they're not a family farming business. We'll look at the requirements for Chapter 12 in a minute. Chapter 12 is difficult for farmers because it was designed for the largest businesses. So it's very complicated. It has a lot of cost. It has a lot of paperwork. It has some big hurdles for family farms that are trying to efficiently resolve their debt problems and continue farming. Also, tax problems can really prevent right sizing. And so, what I mean is, let's say that you file a bankruptcy petition and it's determined that you really could continue to farm if you were able to sell off this little parcel of land that you own. Well, you could sell that little parcel of land off that you own, but what's going to come along with that sale? If I sell land that is appreciated in value, I'm going to have a lot of capital gain, which of course incurs a capital gain tax problem. I'm going to have to pay tax on that gain, usually 20%. And so now I not only have all this pre existing debt, but now I have this tax bill. And if my plan has to find cash to pay off the tax bill in addition to the debt, that right sizing that looked like a good idea won't be. It will not help me. And so chapter 12 is actually going to have a solution for that, but chapter 11 does not. Creditors can often prevent farmers from retaining the assets they need to farm in a Chapter 12 because of the veto power that they have in many cases. And so, Chapter 12 in many cases is just not workable for many family farmers. And that is why it was back in the midst of the financial crisis of the 80s that Congress created Chapter 12. And it was made finally permanent in 2005. But the point of Chapter 12 was to create a bankruptcy chapter that was intended to work for family farmers. And so, some of the advantages that we have with Chapter 12 that we don't have under other chapters is that a farmer can downsize or right size without tax liability preventing those options. We'll look at the details in a minute, but essentially, I sell the parcel and that tax debt gets relegated to unsecured creditor status. And so the IRS will be treated just like any other unsecured creditor in creating my plan. Also, debtors can usually retain assets even though the unsecured creditors do not receive full payment for their claims. So, there are special rules that we'll look at in terms of what the plan does require, but the absolute priority rule of Chapter 11 does not apply in Chapter 12. Also, a debtor can reduce the balance of secured claims to the fair market value of the collateral, and that includes the claim against the farmer's house. And then some other advantages are we can stretch out payment terms, we could re amortize adjust the interest rate. Now, that was especially helpful in the 80s. It might not be so helpful in today's environment, but in the 80s, some of you may recall some farmers had 20% interest on balloon notes, things like that. And so during that period, it was really helpful to be able to say, oh, now we get to restructure that debt. We get to lower the interest rate a drastic amount. We get to stretch out the amortization period for that debt. And that was enough in many cases to get the farmer over the hurdle and to be able to continue farming. Some of those protections may not be so helpful in today's current environment. Now, payments can be made on a monthly, yearly, other basis depending on the income stream of the farm. It is very attuned to the fact that income comes in spurts, right? So it's different than some other types of plans. And then a farm debtor does get to also operate as the debtor in possession. And that means that they maintain the right to continue the farm, to make the farming decisions while they restructure their liabilities. Now, there is a trustee appointed, but the trustee generally is just kind of watching over the proceedings. The trustee does not take over and run the business. The process is efficient and it's generally pretty economical. So, if you qualify and if you're able to create a feasible plan, Chapter 12 can be a good solution. For most farm debtors, the most challenging Chapter 12 requirement is feasibility. And that is really the problem that we have in today's current environment. If a farmer is struggling to make ends meet, they don't have a lot of cash flow, they need to have some way that they can restructure so that after their restructuring, the cash flow will return and they will be able to make the payments required under their plan. If the farmer doesn't have a lot of assets or all of the assets are secured and there's not a lot of availability to lower interest rates or stretch out the payments over a number of additional years, Chapter 12 may not be available because it may not be possible to construct a plan where it's possible to have payments and continue the farm business. And so this is why you need to consult with knowledgeable bankruptcy attorneys who can really walk you through this. They will know, they've got experience, they know exactly how to see if you're a candidate for Chapter 12 or not. In recent history, I saw a statistic a while back that fewer than 50% of Chapter 12 plans have actually been successfully completed through discharge. And that's just because, if you are having financial impairment because of low commodity prices, high input costs, um, it may be tough to make a plan cash flow moving forward as well. Now, what are the requirements? Because if you can create a feasible plan, Chapter 12 does have some fairly strict requirements in terms of who does qualify. Remember, it's designed for the family farmer, not just for a general debtor. So the statute actually calls it a family farmer or family fisherman with regular annual income. It's a reorg chapter, right? So again, you have to show that you're able to continue farming. This is not a plan for somebody that wants to get out of farming. That's when we go back to the chapter 7 that we talked about. In order to be eligible, you have to be engaged in farming at the time of the filing. This isn't a plan for former farmers, for people who are in farm adjunct businesses like seed corn sales, something like that. This is actual farming. This isn't a chapter for somebody that just leases out their land. But if you are a farmer and you are farming, it is possible in some cases that your off farm income can be used to make payments under your plan. So it's not exclusively limited to your farm income, but you have to be farming. Now, we also cannot have debts that exceed $11,097,000 currently in 26. Now, for many years, the debt limit was much lower, and it was in 2019 that Congress passed a law that increased the debt limit. So that did make Chapter 12 available to more farmers. And so every 3 years, that number will go up, but currently it's just over $11 million. We also, as individuals, 50% of your index adjusted debt has to arrive from your farming operation. So your income has to be at least half related to farming. And one good thing is that your debt for that purposes doesn't include your home mortgage unless you've got your home securing your farm debt. But if you've got a home mortgage and your home's over here, you don't have to count that in the 50% calculation, which can be helpful. Also, you have to have earned more than half of your gross income from farming in the last year, or if that wasn't true for the last year, in each of the second and third years prior to the filing. Again, this chapter is only for people who are very dependent on farming for their livelihood. So, over half of their gross income has to come from farming. Now, what is gross income? That is your income minus your cost of goods sold. So it's not gross receipts. So if I uh, if I sell, if I have cattle that I purchased and then I sell them, it's not the sales price of the cattle. I do get to subtract the basis of that cattle when I'm making the determination of my gross income. But it is income, it's not net farm income at the bottom. So tax return data is the prima facie evidence of gross income. So on a Schedule F, we'd be looking at line 9. We wouldn't be looking at the net income after expenses. Now, entities also can be eligible to file Chapter 12. Corporations, partnerships, LLCs, they're all eligible, but they too have to meet the family requirement. And so more than 50% of the outstanding stock has to be held by one family. The relatives is a pretty broad term, but it has to be family owned. The family has to be conducting the farming operation, not just owning the land. And at least 80% of the value of assets consists of assets related to the farm. And they too have the indebtedness limit of $11 million. Then they also, the entities, they have to have 50% of their debts on the date the case is filed arise out of the farming operation. And you can't have a corporation with publicly traded stock qualify for this. So now that we've looked at the requirements, let's just kind of walk through what happens if you do file a Chapter 12. So, what you would do is you would work with an attorney. There's a lot of process involved because, again, the first analysis is not, oh, let's get our bankruptcy petition filed. The first analysis is, do I really have to file for bankruptcy? Or can I work with my creditors to restructure my debt? And that would be preferable. But if we get to the point where we have no options, we've been through mediation, we've done all the things, and then we've worked with our attorney and it looks like Chapter 12 is the way to go, then the farmer becomes what we call the debtor in possession. We're going to file a schedule of assets and liabilities. We have to list everything that we own and everything that we owe. We have to tell the court all of our current income and expenses. We have to list all of our unexpired leases and executory contracts. That is one thing in a bankruptcy that the debtor will at some point have the ability to either they could get out of unexpired leases or contracts, for example. So we all know the deal that you cannot get out of a lease once you've signed it without penalty. But in bankruptcy, You will have the ability sometimes to get out of unexpired leases or executory contracts that are not beneficial, and you'll also have the ability to continue them if they are beneficial. And then you have to file what's called a statement of financial affairs. Now, husbands and wives, they can file joint petitions, they can file individual petitions. And just like every other bankruptcy, as soon as that petition is filed, there's an automatic stay that says, stop, creditors. You can no longer call the debtor. You can't initiate any foreclosure proceedings. You can't file any liens. You can't do anything to collect on your debt for a time. There's that pause while everything gets in order. Now, the trustee, as I said, is going to be appointed and they're going to oversee the process. They're going to be the one that the debtor is going to pay. And then the trustee will be the one to pay the unsecured creditors, for example. But the trustee is not the one that's going to be managing the farm or making the farming decisions. The debtor is going to remain in possession, in control of the farm, unless they would somehow be removed for cause. Now, within 90 days of filing the petition, the debtor, working with the attorney, is going to file a proposed plan. And usually, with a Chapter 12, the goal is to have this bankruptcy plan wrapped up in 3 years. There is an option that if there's good cause, you can extend it to 5 years, but typically a Chapter 12 is designed to be over in 3 years. And the requirement for unsecured creditors, in order to be approved, is that they have to be able to receive as much in under your plan as they would in a Chapter 7 liquidation. So that avoids the absolute priority rule. It means that farmers can retain some assets or equity in assets. You just have to be able to check the box that the unsecured creditors are going to be treated as well as they would if you just sold everything and moved on. So the plan does require that all net disposable income, so you're continuing business, you're in business, you're going to have some income, and you're going to need some of that income to live. And so there are schedules and rules about what is disposable income, what is not, what is required to live. Of course, that's all very set forth with structures and tables. But all of your disposable income has to be distributed to unsecured creditors during the plan period. And that goes for the full 3 years until discharge. You also have to provide full payment in deferred cash payments of all priority claims unless there's agreement otherwise. And then you have to provide the same treatment for each class or claim of interest within a particular class unless there's an agreement otherwise. Now, we can modify our mortgages, we can modify our contracts, we can re-amortize them over longer periods if we can get the interest lowered. If the interest at the time that our note was signed was higher than today's rates, we can get that lowered, stretch out the payments. Again, we can assume or reject contracts or leases that may be beneficial or not beneficial for us. And then again, the debtor can continue the farm operation. And then the debtor is looked at as a fiduciary of the bankrupt estate. They have to pay all the taxes that are owed to both the IRS and to the state authorities. Now, during the time that the bankruptcy plan is in place, so for that 3 year period, they can use the proceeds from the sale of grain or livestock or milk that's not already pledged as security to live on. They can use it to pay other farm expenses. They can obtain unsecured credit in the ordinary course of business because, gosh, otherwise, if you can't feed your animals or pay for your inputs, in those cases, those that credit is an administrative expense, so those creditors will go higher up in the line. They can right size the farming operation by selling assets. Like we said earlier, it might be that you owed a small parcel of land outright, and if you just sell that, then you may be able to pay off some of the debt that you need to pay off. And you can get court approval and do other things too. You can get court approval to sell property in the non-ordinary course of business. So selling machinery that's not just a trade, but just like liquidating machinery, liquidating a livestock herd, using your cash collateral, all these things, you can do them as long as the court approves. And then within 45 days of the debtor filing the plan, remember the plan has to be filed within 90 days. And then within 45 days of that, the court will hold a confirmation hearing. Now, creditors could come to this hearing, they can talk in the hearing, but they're not. The unsecured creditors are not going to have that vote that they do with like a chapter 11. So to be confirmed, the debtor is going to bear the burden to show that the plan meets all the requirements. And so in order to be confirmed, the debtor has to prove that the plan was in good faith, all fees and costs are paid, that the plan meets the best interest of the creditors test. And what is that? Well, the property to be distributed to pay unsecured claims is equal to or greater than the amount that would be paid if I was just liquidating in a chapter 7. Also, the plan has to provide for secured creditors in one of three ways. So secured creditors are the ones that have collateral, and you're presumably using their collateral while you're farming. So there has to be some protection for them. And so you can agree with them on anything, or you can give them their collateral, or you can allow the secured creditor to retain the lien and receive the present value of the secured portion of the claim. So if the creditor has collateral that is less than the debt that you owe, their secured portion is only in the amount of the present value of that collateral. And that is the portion for which they have extra protection. Otherwise, they're treated for the rest of their debt like an unsecured creditor. And if they do have property that is collateral that you are using in your farm operation, you do have to show through your plan that they have adequate protection, that their interests are protected, that you're not going to use up the collateral so that after the plan is over, they would have nothing if they're not paid up to the value of that collateral. Also, as we said, the plan has to be feasible. You have to show that you can make the required payments. You have to show that here's my cash flow that I'm expecting, and here's where that cash will go. It will go to these creditors. It will go to my living expenses here. Here's how I'm going to operate my business. All of that is part of a Chapter 12 plan. And then the debtor has to be current on all post petition domestic support obligations. They can't stop paying child support, that type of thing. Now, if an unsecured claim holder or the trustee objects in a hearing, to confirm the plan, this is a big difference from Chapter 11. The court will still confirm the plan as long as the debtor has shown that all disposable income is going to be used to make payments. The value of the property to be distributed is not less than the debtor's disposable income, or the property to be distributed has a value as of the effective date of the plan not less than the amount of the claim. So those are all important components of a plan confirmation. And then once the plan is confirmed, what the law does is it vests all the property of the estate with the debtor, and the property will be free and clear of any claim or interest of any creditor provided in the plan, because the creditor is going to be provided for by the terms of the plan. Now, what is a discharge? At the time that the 3 years is up, if it's a 3-year plan and all the payments have been made, the debtor is going to get a discharge. Debt like alimony or child support, like we said, that's not dischargeable, but the discharge is going to cover all debts that were provided for by the plan, with the exception of any secured debt. So in my plan, I might have said, okay, I'm going to reaffirm my debt to the secured creditor, and that mortgage is going to extend beyond the payment terms of the plan. If the creditor agrees to that, then of course they retain their lien on that property, on that collateral. They retain their security interest, and that is not discharged. So down the road, if the debtor doesn't pay, that creditor can get that property. And so again, except for anything that's accepted, the creditor, the debtor will walk away with a fresh start, able to proceed without creditors having any remedy against them. Now, I want to go back to explain a little bit more about how taxation works in bankruptcy, because this was one of the benefits of Chapter 12, that I could downsize or right size or sell something in order to help make a plan feasible and not be saddled with tax liability that would cripple my ability to make my payments, right? So, how do we do that? Well, it's through a special law that was passed by Congress. So, first of all, if I have a chapter 7 or a chapter 11, I'm going to create a separate taxable estate. And the trustee is going to file a Form 1041. The debtor assumes tax attributes at the conclusion of the proceedings. It's different. Chapter 12 doesn't create a separate taxable estate. If I'm a sole proprietor farmer, for example, and I'm in bankruptcy, I'm going to continue to file my 1040. I'm going to report all my income, and I'm going to deduct all my expenses. And canceled debt is not included in income. We'll look at the reason why. There's a special exclusion for debt that's canceled in a bankruptcy. So that's helpful. No taxation on that. But let's look about tax claims against the estate and how are tax claims handled in a bankruptcy. First thing to understand is that if I come into a bankruptcy, if I file a bankruptcy after, let's say, the IRS has already perfected its lien, then that's a perfected tax lien. That's a secured claim. So that is already done. A tax lien is going to arise at the time that the tax is assessed, and then it attaches to all of my property. It also attaches to my after acquired property. But a tax lien is only perfected when the IRS or the taxing authority files a notice of a federal tax lien in the appropriate public office, filing office under state law. So there are many times when someone will have a tax lien against their property, but if it hasn't yet been perfected, then it is not a secured claim. And so, because the IRS could enforce its lien even after the tax debt is discharged, bankruptcy should be filed before the IRS perfects its lien. You see, there's reasons why different timing of different events is important. This is again why you absolutely have to work with somebody that's very experienced in farm bankruptcies. You can't just go to somebody that just hangs a shingle and says, I file bankruptcies. And you certainly can't go to somebody that isn't schooled and skilled in bankruptcy. It's really its own practice area. I find that most attorneys that practice bankruptcy, they're really specialists in financial distress and bankruptcy, and that's a big, big part of their practice. So creditors, including the IRS, they have to file a proof of claim with the bankruptcy court. A claim for taxes can be secured by a perfected tax lien, or it can be an unsecured claim if the lien hasn't been perfected. And then again, if the lien has already been perfected, it's going to generally pass through the bankruptcy proceedings unaffected, even if my personal liability for the debt is discharged, right? The IRS or the other taxing authority is still going to have an interest in the property. And then outside of Chapter 12, most tax claims are priority unsecured claims. So if I'm not filing Chapter 12, if I'm filing under another chapter, it's a priority claim. But in 2005, Congress said, well, we're going to give a little extra protection for family farmers. So we're going to say that claims owed to a governmental unit that arose as a result of the sale, transfer, exchange, or other disposition of a farm asset used in the farming operation, the law at that time said they were treated as general unsecured claims subject to discharge. Now that was very helpful. It's called priority stripping. And it just said that, you would be able to actually discharge that tax liability that arose from selling, let's say, that parcel of land so that you could pay off other debts. You could treat the capital gain tax liability as an unsecured debt that's dischargeable in the bankruptcy. And that is very helpful because otherwise it was very hard to create a feasible plan if what you needed to do in order to get one was right size or downsize. Now, what happened after that law was passed was a series of court cases that kind of shined a little confusion on it. And in the end, the US Supreme Court weighed in and said, okay, this law only applies if you were able to sell those assets, if you right sized or downsized before you filed your bankruptcy petition. And so that was a little bit hard because once the bankruptcy petition was filed, anything that was sold still had the tax liability that would be a higher priority claim. It could not be discharged. And selling before the filing wasn't always practical. So, because you didn't know for sure what your plan was going to look like, because of course the plan is created after the filing. So, back in 2017, Congress fixed that problem. They created a new law. And so now what the law says is an unsecured tax claim that arises before the filing, after the filing, or before the discharge as a result of the sale, exchange, or disposition of property used in the farming operation is treated as an unsecured claim, shall not be entitled to priority, shall be discharged. So again, it is subject to discharge as are other unsecured claims if there is not adequate property to go around. The fact that you cannot pay all of your tax debt does not prevent you from creating a feasible plan. And so when we're looking at this, we look at the law and we just say, okay, what property is included? And, there's still a little bit of gray area in here, but there have been courts that, of course, that applies to the sale of land and machinery. There have been courts that have also allowed it for the sale of grain, for the sale of livestock. uh, there is a split over crop insurance proceeds. So again, not 100% sure on how every sale would be treated, but primarily it existed so that you could sell your land or your machinery and not be saddled with that tax debt. So before you file Chapter 12, really the analysis is determining whether you can cash flow a plan. You have to really look at the liquidation value of the assets to make sure that the unsecured creditors would receive as much under your plan as they would if you just sold everything. And then you really have to consider the timing of the plan with respect to the sale of assets. Again, trying to file it before any liens are perfected is helpful for the debtor. You have to look at tax attributes, those types of things. And then, as we mentioned earlier, there is another tax provision that always comes into play anytime that debt is discharged. And so the general rule is that if I owe a debt and that debt is discharged, then I will owe tax on that amount that was discharged because essentially it's income to me. But Section 108 of the tax code says, in some situations, we recognize that policy should allow debtors a true fresh start. And so we are not going to tax cancellation of debt income if it was canceled in bankruptcy. if it was canceled when the debtor was insolvent, if the canceled debt was what's called qualified farm debt. We're not going to go into the definition of that, but certain farm debts, if it was qualified real property business debt or qualified principal residence indebtedness, all of those things can be subject to not have to pay tax on the cancellation of debt, which can also be a helpful provision. So I guess that was the summary of how Chapter 12 works, how bankruptcy works, sort of in general. Again, very high level view, not intended to make anybody an expert in any way, shape, or form, but just to kind of give you a roadmap for what might be ahead in a bankruptcy. The best advice is that if you're having any sort of farm financial distress, if you're having issues where it's difficult to pay your creditors, you really need to consult with a qualified attorney, a qualified farm financial specialist as soon as possible. The sooner you talk to someone who can help you, the better. Again, the best solution, if possible, would be non bankruptcy reorganizations. Maybe it's possible to renegotiate your debt, work with your creditors, work with the businesses. A lot of times these groups will work with debtors, but when that's not possible, bankruptcy is a good option, but again, you have to seek qualified counsel that is experienced in this area. And so with that said, I'm going to see if we have time for just a few questions. If there are questions you want to put in the question box, that would be great. um, any questions out there? I don't see any. Anybody still online? You could type something in, and I'm looking at the questions out here and happy to address anything you have. I think this was recorded. You can also reach out to me. I'll put my contact information back on the screen. I'd like to hear from people through email or phone calls. Feel free to reach out just individually as well. And I'm happy to talk to you and point you to additional resources. And I just want to thank everybody for being online. But there are that's my contact information. Feel free to reach out. And again, thank you for participating in this webinar today.
Um, Thanks, Christine. Um, doesn't look like we have any questions. And so with that, I will remind everyone that this was recorded and you will receive an email in about 2 weeks letting you know that this recording and the slide deck has been posted to farmers.gov/taxes. And if you would like to check out that website in the meantime for previous webinars that have been done, please do so. There's a lot of good information there. Checking again there with no questions being there. Thank you so much, and everyone have a great day.